Welcome to Objection to the Form. This is Justin Humphreys, and I'm here with a special guest, Steve Baynard. How you doing, Steve?
I'm doing great, Justin. Thanks for having me.
Steve is the former president of what's now the 6th District Judicial Bar. And one of the things I wanted to talk about today is exactly how the bar association is organized and the various districts and what they do and what they don't do, because it's something that took me quite a while to learn, and there's a lot of confusion about that.
Yeah, there really is. I'm the immediate past president of the 6th Judicial District Bar, which we just changed. We were the 5th Judicial District Bar for forever. And I was actually president of the 5th Judicial District Bar back in 2005 as well. So you've got the North Carolina State Bar, which is the licensing body for the lawyers. So your certificate that's on your wall is your certificate from the State Bar that allows you to practice law. The bar exam is issued by the State Bar. The North Carolina Bar Association is a voluntary bar that does a lot of equally good things that the State Bar does. But you don't have to be a member of the Bar Association to be a lawyer. You got to be a member of the State Bar. So then each district is broken up into multi-county districts. So the 6th district, I can still say 5th because it's what I'm used to, but the 6th district is Pender and New Hanover counties. And then each district elects a bar counselor who is basically like your representative in the law legislature, if you will, at the State Bar. Brother Cobb is our bar counselor right now, who we elected this last time.
And that's something I'd like to know more about. What exactly does the bar counselor do?
Yeah, the bar counselor is our representative for our state bar. You know, the lawyers are self-regulated, so the state bar is who regulates us. So they serve on 3-year terms, and I think he can do 2 or 3. I can't remember exactly how many he can do. Steve Colberth was one. Bob Johnson was a bar counselor. We've had, obviously a good number of people. It's usually folks that are unilaterally respected among the bar that get elected and do that job. So they go up there. They have committee meetings once a quarter. They're there for about 4 or 5 days. They vote on various ethical rules. There's all kinds of different committees that they serve on. Of course, they decide who gets disbarred and who gets censured, or if there's any kind of complaints or problems, they decide a lot of those sorts of things.
The bar counselors make those decisions?
They do.
And so what I always thought of the bar counselor is somebody you'd contact if you had an ethical question, maybe outside of going directly to the state bar, or maybe if you felt like you observed some unethical conduct and you wanted to kind of screen it before making a report or telling on somebody, so to speak.
Right.
That's what I always understood the bar counselor to do. Do they have any responsibilities like that? Or
They do. I mean, they're a great sounding board to go talk to because they're the people that are on the front line that know what the new ethical rules are going to be. There's all kinds of things that are being considered all the time. You can call up and ask the bar any kind of question that you have anonymously, and they have different lawyers who do nothing but enforce the ethical rules. And they'll give you an advisory opinion as to whether you have a conflict of interest or whether you're doing something ethically wrong. And you can go to those bar counselors and they know. But you can also, there's other recourses. I was also on the Chief Justice Commission for Professionalism, which is an organization that was set up back in 1998 by Burley Mitchell when he was the Chief Justice. Your secured leave that you have as a lawyer, where we all get 3 weeks of secured leave,
yes,
is a direct genesis of the Commission for Professionalism. Us that right.
Mine starts tomorrow.
Okay.
I'm stoked, yeah.
Exactly right. Well, you're dressed right for it,
yeah,
man. I wish I was dressed like you right now.
I'm ready to get out of here.
But it used to be that you were at the beck and call of a judge. So if you had a very active trial practice and you wanted to go on vacation and your case got called for trial, the judge could literally just say, sorry, you're going to try this case, and you'd miss out on your vacation. With a secured leave now, as long as you follow all the rules about how far you do it out and all that kind of stuff, you're good.
That's one of the things that really sucks about federal practice is, unless it's in your order,
right,
or, there's no kind of just blanket document you can file at the federal level. And that's something that certainly, caused some consternation in the past, especially with the way they just decide they're changing things. And,
yeah,
what are you going to do?
No, for sure. And that's the Commission for Professionalism. It does a bunch of different things. They've got a judicial response committee. So let's say a judge gets kind of slammed in the newspaper for maybe letting a criminal go on a technicality or something like that. The judges ethically aren't allowed to go in the newspaper and kind of speak up for themselves. They're not allowed to do that. So they can go to the Judicial Response Committee, which is part of the Commission on Professionalism in Raleigh, which is run by Mel Wright, who's the I guess the CEO of it, the head guy. And you can call him, and they usually have a group. I was on one of those committees too, and it's usually it was a kind of a lot of. I don't know why I was on that committee, to be honest, but I was on that committee. Probably do more for grunt work, but Judge Arnold was on there. I was on there with him. Former Governor Holshouser was on there, and then they can go out and explain in the media why a judge may have made a particular ruling to try to defend him a little bit.
How often does that happen? I don't recall ever seeing, and I don't watch a lot of local news, but I don't recall ever seeing a local judge or somebody advocating on behalf of a local judge explaining a controversial ruling or something along those lines.
And I have not seen that much down here. I had been involved in those. They're usually in the central part of the state and around Charlotte, I guess, the bigger metropolitan centers. But any of those that I've ever been involved in, it was always like Winston-Salem, Greensboro, Charlotte. Can't think of one I did in Raleigh, but haven't had one here.
They kind of go after each other in that area, don't they? The Guilford County.
Yeah, I mean, it's if I practice mainly in southeastern North Carolina, but like as a rule, we don't file a lot of Rule 11 kind of things against each other. Just practically speaking, you don't see that very often down here in southeastern North Carolina. You see that a fair amount up in the central part of the state, and I think it's because they're bigger, and you don't see the same people all the time. I mean, you and I have to deal with the same folks all the time, so you tend not to burn those bridges when you got to maintain a relationship. But it's a little different up there. They're still very professional. I'm not trying to say anything like that, but then they even have with the commission, he has the Professionalism Support Initiative, which we run through our bar, which is let's say it's not an ethical violation, like a lawyer is profane or a bully or something like that in a deposition or something like that. That might not be an ethical violation, but it might be a professionalism violation, because your ethics are the basic kind of things you have to do just to be a lawyer and keep your license. Professionalism is kind of a little bit above that, a little bit.
What kind of sanctions or repercussion or punishment can you face for being unprofessional?
Nothing. And that's what the Professionalism Support Initiative is. And it's actually engendered in our articles for our bar. And the last 3 immediate past presidents serve as the board members on that. And what you would do is, typically you would call the state bar. Some individual would call the state bar and file a complaint. And they say, that's really not an ethical violation. Let me refer you over to the Commission for Professionalism. Mel would then go out usually and either reach out to your organization of that professionalism in your county, or he might go find a lawyer who maybe knows that lawyer and kind of do an intervention, completely voluntary. If they don't want to do it, they don't have to do it. There are no ramifications. It's totally confidential. I've done a number of those before where maybe somebody's not calling their clients back in a timely fashion and they're getting some complaints. So you're trying to nip something in the bud ahead of time. And it's usually uncomfortable in the beginning, and the lawyer gets upset with you. But once you start talking through everything and kind of getting it all out on the table, it tends to resolve itself. It's been a good tool.
Yeah, I imagine that'd be a difficult situation, going down and sitting with an attorney and telling him you might need to rethink the way either you're behaving or the way that you're running your practice. Yeah,
it usually helps. I've done it at times. You got to have somebody who they trust, who's a friend of theirs, and you bring them in to kind of let them know it's a safe place. And then it starts off poorly, but then it moves through really well. And I think it ends up a lot better. And what's interesting about it is you can even do it to judges. If you believe a judge is not being professional for whatever reason, you can report the judge. And I've had to do that on that initiative committee.
You had to be the one making the report, or you had to participate in the intervention?
I had to sit down with a judge and talk to a judge about accusations, and that was not fun.
So when you do that, do you bring the complainant in with you?
No,
or
no.
I imagine you'd want to stay anonymous if you'd made a complaint like that about a judge.
It's completely anonymous. It's completely they're not going to know who it is. And I'm not going to say who the judge was or anything like that, but you sit down and just kind of have it. You talk it through. You really need another judge with you to do that.
Well, and I imagine when you're approaching them, I mean, it's one thing to say somebody that doesn't call their clients back probably has maybe hundreds of people that they haven't called back. But if you're going into a judge and you say, well, the way you acted in that trial, then they're probably thinking, all right, well, who did I screw over in that second? That's who it was. That's who made the complaint.
Yeah, and I think that's why it's particularly hard. Is I think they can kind of figure out pretty quickly. And usually the ones that I've been involved in those situations, it's usually district court I've never really been involved in a Superior Court just because Superior Court judges move around so much. In District Court, sometimes people perceive that they might be friendlier to a particular lawyer because it's a friend of theirs or somebody they've known a long time, and that seemed to be where those kinds of things came up. And it's it gets handled very, very well, though.
Well, especially like in those family law cases, you're dealing with the same judge throughout the pendency of the action, and you might have 5 or 6 Superior Court judges touch your trial throughout the course of when it's going on. But imagine if you feel like the judge assigned to your case has a vendetta against you, and that's a third half of your caseload. That'd be a problem.
Right. Yeah. No, that's exactly right. That's exactly what it is.
Well, I had no clue that those kind of things exist, and I'm kind of glad to hear it. It sounds like a good idea, and while there might not be any teeth behind some of it, at least bringing it to somebody's attention. Maybe sometimes people don't understand.
Yeah, I mean, even if you can get rid of, if you can make 10 or 20% of complaints not rise to the level of an ethical violation by intervening early, it's good. And then the State Bar and Bar Association they have PALS, which is for drugs and alcohol and that kind of substance abuse type dependencies, where you can go and they'll help you out if you've got problems in that kind of regard. We've got Bar Cares here in this county, which is if you feel part of what the reason the Commission for Professionalism was started was because they did a mental health study of lawyers, and like 60% of lawyers were hated their job, and I can't remember what just the stress of it all. And they started it to give you vacations, and then also to give you the opportunity to try to make things. I think it's
better. Lawyers and dentists maybe that hate their jobs the most.
Yeah,
and
I've always thought being a dentist would be great, but I don't know.
You ever seen that movie?
No,
I think it's a series. There's 5 of them. It's scary. It's scary stuff. It's about a killer dentist. And, it's kind of a
all my friends. Go ahead.
Which is a vulnerable position. You're knocked out, and somebody's got a drill in your mouth.
Yeah. All my friends who are dentists, I don't know any of them that work on Fridays. That'd be nice.
Yeah. Yeah. Well, that's cool. That's interesting to know. What are you hearing in terms of how the bar, and in particular what I'm interested in is jury trials, how that's going to be affected by kind of the pandemic and the recent orders that have kind of kept pushing things back?
Yeah, I've heard all kinds of different things with regard to jury trials. I think everything's still on open and available. I've heard that they're going to start jury trials in August, but then I heard it's only going to be criminal jury trials, and they're going to be short. They're not going to do anything long. So if you've got, let's do civil, you got a 3-week long medical malpractice case, I don't think those cases are going to get tried, maybe not even this year. And there's some talk that we might not have any civil jury trials this year. I've heard some talk that maybe October, but when the Chief Justice said August, that's when things are supposed to start jury trials again. But I think that's going to be very limited and low key, and all kinds of things. Think about handing out exhibits.
Yeah.
If you want to hand out exhibits and each juror's got to handle the exhibits, how do you do something like that? So the criminal stuff I think is going to take priority. The civil stuff's going to get kicked down. The more complicated civil stuff I think is going to take a while. There's been some discussion about changing jury trials from 12 jurors to 6 jurors, but everyone would obviously have to consent to that.
Yeah, and that's kind of what I was saying. In a lot of these situations, I've seen it where judges have asked if we'd be interested in having a bench trial. Yeah. And it's kind of rare for everybody to want to be on that same page, shifting gears. I mean, there's been times in advance where I've agreed with opposing counsel to do a bench trial, but usually when you're this far along and everybody's requested one, at least one party wants to keep the jury.
Yeah.
And so it sounds like most of the workarounds would require everybody agreeing or consenting.
Yeah, no, I think it's similar to, I've done actually a bunch of in-person depositions, not on video. And I've done some in-person mediations and then some WebEx and Zoom and all that different sort of thing. I haven't had a hearing in the courtroom yet in front of a judge.
Are they doing those now, or is that all WebEx?
They're doing them. There was a calendar call. I'm trying to remember where it was. There was a calendar call a week ago. I want to say maybe Brunswick County, but don't quote me on that. But I know I have motions calendared for August 1st in Onslow County, and Judge Quinn is going to be in the courtroom on August 1st, is what Brittany Odom, the TCA, says. So they're starting.
Now, is it your choice if somebody, let's say you've got a motion calendared and the other attorney doesn't feel comfortable, is that attorney able to say, look, Steve, I'd rather just do this by WebEx at home, or is it, no, you've got to be there before Judge Quinn?
That issue came up with the trial court administrator, and she told me that everyone has to consent if you're going to do video.
I gotcha.
Everybody. So if the one lawyer says, no, I want to do it in person, then the other lawyer has to show or send somebody to it. As of, I think that's the July 31 deadline is the latest. Because, she kicked, Chief Justice Beasley kicked everything, statute of limitations and everything, to July 31st.
Gotcha. And what I've seen is, like when I went to the new federal court that I guess they're running off of 17th Street, and they appear to be doing business as normal, at least on the criminal matters. But then I helped a buddy out with a traffic ticket a couple days ago, and they had, they didn't have any officers there. They kind of had the big glass protective shield, to protect the judge behind the bench, and but besides that, it was kind of like a. They had a place where you could submit your order under the protective window, and It seemed to be fairly normal, other than kind of the shields and whatnot.
Yeah, even during the height of the concerns, when everybody was really sheltering in place in April, I was going down to the courthouse, and the clerks were all in there, and they were filing stuff, and I got a couple orders signed by judges and got those filed, and not necessarily by consent. They were more like time-oriented type things where the other side had something they had to do within 14 weeks and they didn't do it, so the judge signed the order.
How do you think it's going to impact? How do you think they're going to handle the priority of cases once, hopefully, when things get back to normal? Where, for example, let's say I had a trial scheduled for April 1st,
right,
and then we're back to business beginning of next year.
Yep.
Does that mean my trial that was scheduled for April, is that going to be first on deck, or would it be the guy that's had been scheduled for the 1st of January the whole time?
Yeah, I think that's going to get super complicated, because I think the first thing they're going to inquire into is how long is your trial. And I would say if you're looking at a 1, 2, 3 day trial, you're going to move up the food chain in those cases, would be my guess, because they're going to try those first. And so I would say some of those kinds of cases, they're obviously going to go by how old your case is again. But if you've got a complicated case that's old, I would imagine you're going to get moved down the calendar, and they're going to move somebody up who's got something small. But, frankly speaking, you go to calendar call anymore, and there's just not that many cases for trial. It used to be back 25 years ago, everything was marked for trial, it seemed like, and got tried, but it just doesn't happen like that much anymore.
Yeah, and a couple of weeks ago, I was talking with Jeremy Wilson about this. That in my experience, what I'm seeing is it tends to be the smaller stuff that's being tried.
Yep.
I guess there's a lot of times the expense of trying a complicated matter is too great, or a lot of times there's too much to lose.
Yep.
If it doesn't go your way, it's not like the smaller cases where you can live with the results. So is that kind of what you're seeing, or?
Yes, absolutely. The bigger stuff doesn't seem to be getting tried as much, unless, like the med-mal stuff still seems to be fairly steadily moving along, and those big cases are getting tried. But a lot of the smaller civil stuff, that gets tried a fair amount, because like you said, there's not much to lose by either side. Either the plaintiff's kind of rolling the dice because they don't think they've got a great case, but they'll give it a try, or the defense is like, I don't really have that much to lose. Whereas, if you've got a big damages case that's got a strong liability component to it, then there's a lot to risk for both sides. The plaintiff could walk away with nothing, or the defense could get hit for $1 million. And those cases tend to settle. Yeah. Especially mediation, I think, has driven all of that. As mediation was mandated in 95, 96, I think. I'd been practicing for 2 or 3 years when Superior Court mandated mediation came about.
What was it like prior to mediation?
It was a lot more like the Wild West. You would, there were some lawyers that didn't really prepare, but what they were really great at was on their feet in the courtroom, just without a whole lot of preparation. Back in the day, we didn't have to do all this discovery that we have to do now. So you kind of know what each side is going to say before you really get to trial anymore. And now with mediation, everybody almost kind of gets ready, not for a trial, but you get ready with your whole case, because your client's sitting there with you and you need to present your best day in court or what you think your best day in court is, and the other side's going to present their best day, and everybody's got to sit there and listen. That used to happen on Monday mornings in front of the judge, and the judge was the mediator. And by that time, everybody spent all weekend getting ready. Everybody's locked and loaded. You just go try the case about half the time.
So I took the South Carolina bar, and in order to you can have your license, but in order to participate in court or to take depositions or to do litigation or criminal work, you have to have your trial observation certificate. Yep. And so what you had to do, at one point you had to watch 10 trials. And by the time I got my license, it was 4 trials, and it was different things. Like you could do one family court matter, you could do an admin matter, a criminal, and a civil.
Sure.
And
makes sense.
Yeah, at that time, that was probably early 2008. Or later 2008, 2009, when I was trying to get those certificates done. And Horry County and a lot of parts in South Carolina were in the earlier stages of ADR and implementing mandatory mediation. And it was kind of it was very frustrating for me, because I would call the attorneys and explain to them what I was doing and ask them if they thought, because there were requirements, you had to have 2 witnesses on each side, and you had to have certain things. And so I'd say, hey, does this trial qualify? I'd say, yeah. And so the first one I went to, I came in, the judge brought everybody into the room. I was there for like 2 or 3 hours, come out, and they announced it settled.
Yeah.
I was like, well, this is a waste of time. And so I was like, well, I'll figure it out next time. So then the next time I had an opportunity, I think I'd drive down to Georgetown or somewhere like that. Yeah. Call all the lawyers in advance. Like, no way, this is 100% going to trial. We're so far apart. We'll never agree. We'll never settle this. Sure. Same thing happened. Yep. The judge pulls them in there. They were there for several hours, and then I'm driving back with empty-handed again. Yep. And from what I had been told from a lot of the lawyers that were here in North Carolina prior to mediation being mandatory, that was the way things worked. It was like a lot of times the judge would lean on the parties or kind of give his or her take pre-trial, and then that would kind of motivate the parties to settle.
Yeah, and usually there's in almost every jury trial, there's 2 or 3 key evidentiary issues that are in the judge's discretion, right? Yep. So he'll take you in the back room and sit down and start talking to everybody about it and start kicking around the case, and he gets a bead real fast on what those key evidentiary issues are. And if he thinks one side's being unreasonable or the other, he might, I'm not saying they do this.
Yeah, no, I know.
But I mean, I've had those conversations where all of a sudden, he's not looking good. Your evidentiary issue isn't looking good anymore, and you need to go back and talk to your client and say, hey, I'm getting a read from the judge that it might go down like this, and that was one of the things we were worried about. And and they've got a lot of power in that regard to try to get a case resolved, and that's the way it used to all get done like that. But now, usually in a mediation, everybody sits down and everybody gets prepared because we're lawyers. You don't do anything without a deadline, and so those deadlines come up and you get ready, and everybody kind of figures out where they are, and things tend to get resolved.
One of the interesting things, and that's another thing I've been doing recently, is I just kind of started mediating cases. And, for people of kind of my age and my generation, it's almost like the mediation is the trial. Yep. And, we still try them, and, I'll probably do maybe one a year, maybe one. That's probably what I've been averaging recently. So I still get in there, but it is fairly rare. Yep. So it's kind of turned into like the mediation is the trial. Yeah. And so you'll see people just loaded up for they're gonna put on their case, sometimes in the opening, or sometimes they're gonna put it on in their initial meeting with the mediator. Yeah. And they're wanting to kind of disprove everything, and I think there's certainly a time and place for that. But when I'm mediating, I try to I want to get a handle on all the details so I can kind of go through it. But I kind of don't view it as my job to let's resolve this factual dispute and determine who, because that's. Yeah. It's just you can't do that in that setting, and I don't think that's the best way to reach a resolution. But it is kind of that's at least when I was younger, I think that was kind of the mentality of mediation. Like, I'm going to go in there and set the record straight, and then I'm going to tilt the mediator to my side, then he's going to lean on them and beat them down and make them accept my settlement terms. Yeah, no,
I think you just did a mediation for me and did a great job in that case, that's part of the experience of going through and doing the litigation and having the trial experience. So where the leverage points are when you go in the room with the other side, whether, whether, look, you're going to spend this much on an attorney just to get to the finish line.
Yeah.
You know, sometimes kicking in a little extra cash just because you're going to end up spending it regardless, whether you win or lose, you're going to spend those attorney's fees, is a big pressure point in a lot of those cases that get settled and resolved.
Yeah, and that's kind of disappointing because it's, you know, you don't really, that's not really something you talk about in law school is well, we're going to capitulate on an issue where we're in the right because it's too expensive to fight it out.
Right.
You know, it's kind of a, you know, it's not, I mean, it's a reality of what happens a lot of times, but it's certainly not inspiring when you're when you're putting in all that time reading law, and when you're like, well, it doesn't really matter. You're just gonna, you might know the law, but you're probably gonna end up at least making concessions because of the incredible expense involved.
Yeah, no, half the time, you know, I'll have somebody come in a construction case or a real estate litigation. Somebody's home is having troubles and they want to sue the person who sold them the home, and you sit there and you feel like partially like a financial advisor, because you're like, look, we're going to have to hire experts. We're going to have to take depositions of probably maybe a dozen people just to get you to a trial. You know, it might be $25,000, it might be $50,000, and maybe you're fighting over $100,000. And you got to ask yourself, is it worth going through all of that? You know, and that's a big part of it. Unfortunately, it's a good system, but it's an expensive system.
Sure. You know, I think that's what I'd like to do in a second career, is be a expert witness. Yeah. Seems like a pretty good gig, you know. Just and some of them I've seen, and I mean, you know, a lot of the times these guys are a lot smarter, you know, than I am, and they've got a lot of technical knowledge, and they know, you know, they've got their fields, but you know, it's amazing to see how kind of wide some of these guys spread themselves as far as how many things you can be an expert about. And I guess it's, you know, when that's what you do for a living, you can't, it's hard to be a one-trick pony, so to speak.
Oh, no, for sure. And you know, you got to be able to, being an expert is one world, but handling a jury trial and getting attacked by, you know, 2-3 lawyers sometimes on your opinions, that is not a pleasant experience. And that's why a lot of people, I mean, I've had cases before where I'd hired a doctor to give opinions and he just was brutalized by the other side. They didn't do anything improper, just, you know, they went after him on a variety of different ways. I mean, you know, like when you attack an expert, we always laugh, it's a 3-legged stool your expert stands on. He's got his credentials, he's got his facts that he relies on, and he's got his opinions and whether they meet the standard threshold of peer review. And if you can knock one of those legs over, that expert's going to fall and his opinion won't stand. So if they go after their credentials, you know, now that's kind of a personal thing, where they tend to get a little upset. And I, you know, I've had them where they go, look, you don't have to pay me, just don't make me go to trial, because it's been such an unpleasant experience. But you know, it's a special lawyer that can do that to an expert.
One thing, you know, we were kind of talking about the expense, and kind of a lot of times you get this war of wills where it might be where the parties involved spend a lot more money than really even at stake. But you don't want to be the one that kind of backs down, so to speak,
right,
or that takes a loss on the case because of that concern. So a lot of times, my thing that I'm sure every lawyer's heard it a bunch is, well, it's about the principle of the matter.
Right.
And I don't know, like, is that something you've heard a lot? It's the principle of the matter.
Oh yeah, you know, I typically get paid by the hour, so there's nothing a lawyer who gets paid by the hour likes to hear more than this is a matter of principle. Yeah. Because now you're taking my financial advice and throwing it out the door, and you know it's expensive. If you want a pit bull, pit bulls are expensive.
Yeah. So what would you say when I've always heard when somebody says it's about it's the principle of the matter, that means it's about the money.
Yeah.
So I don't know, like, would you say how many times people have really meant it when they said no, it's about the principle of the matter?
They'll usually start off, and then as the bills roll in, and they start to see how much they're spending on it. Usually, you get into the $15,000 to $20,000 to $25,000 threshold, and all of a sudden they're like, how far away are we from trial? And you're like, well, it's 6 months. You know, and that's when all of a sudden the matter of principle starts to deflate a little bit. And you know, and unfortunately, sometimes that's what it takes for some folks. You can't explain that to them in the beginning, and then of course they get mad at the system because it's, because they're frustrated because they didn't get what they wanted, which I totally understand. But
you hear people, I guess the saying that you can sue a ham sandwich or something like that.
Sure.
And that's one of the things that I've seen that really upsets people is when they're saying, why am I even in this? It's kind of why haven't you got it dismissed by now? Or this is frivolous. This is terrible. And there are things in place to deal with that, but really it's kind of you're kind of along for the ride for the most part.
No, for sure. And some of the things North Carolina's tried to do, like as when you file in Superior Court, you just have to put in excess of $25,000. And the reason we do that is because in California, I remember there was a story about a guy who sued his laundry guy, his what do you call? Dry cleaner. Yeah. And he sued him for like $10 million because he burned up a pair of his pants. I forget.
Wasn't that guy a judge that did that?
It was something crazy. Yeah. But, we do in excess of $25,000 because, the newspaper's usually going down there and looking at the new filings to see if there's any interesting cases or anything that's strange in there. And, and then we do the Rule 8 request separately where you find out what the number is, and you don't file that until 30 days before trial. And we do that consciously to try to avoid some of those kinds of improprieties where people are just going to sue somebody to put their name in the paper. Yeah. But, it's hard. There's clearly a predisposition in civil court that's system-wide that they want a jury trial to resolve the issues. It's very, in my experience, you can get summary judgment, but you better have everything lined up just perfectly. Yeah. And you better be able to explain it fairly quickly to get a judge to agree. This
is something that's interested me, and I've kind of thought about it from time to time, but have you ever sued anybody? I'm talking about in your personal capacity.
No.
Because neither have I, and I don't think I want my business out there in the court. Right. But I think there might be a situation, where I was trying to decide in my, my own head, like what would be my threshold? What would it take in order for me to sue somebody? Right. And especially like, I'd hate to do it where I work and with all my colleagues and whatnot. But at the same time, I'm not going to let, just something that needs to be addressed go. Do you have like a personal threshold of when it's like, this is all right, I'm going for it. What made me think of it was the judge that sued the laundromat for millions of dollars for messing up his suit.
I don't know. I don't have a super bad temper until he kicks in, and then my temper I go from 0 to 100 pretty fast. But no, I think I generally try to avoid going in a courtroom but for all costs, and would prefer not to sue anybody unless you had to.
Would you go pro se if you were suing somebody on their behalf?
What is it? Abraham Lincoln says the lawyer represents himself as a fool for a client. Isn't that his famous quote? Yeah, that is. I've had that situation happen before where a lawyer's represented himself, and that is a very true statement.
One of the things that I had was a disbarred lawyer that was representing himself in a case, and that was one of the few times where I've videotaped a deposition, where I was not in anticipation of playing it like an expert or something like that, but I just wanted to, if the guy started acting up because he had been kind of crazy in some of the correspondence I've had with him, like I want to have these pictures because I'm probably going to move for summary judgment where I can play a clip for the judge. And say, hopefully the judge say, I don't want to deal with this guy and kind of drive home the point of what he said.
That's absolutely smart as it can be. The videotape deposition is the way to go if you can afford to do it. And because, and just as well as I do, you read somebody's typewritten testimony and you don't get the inflections or the raising their voice or whether they said it fast or whether they said it slow or whether they stumbled through it or whether there was like a 30-second pause in between a key question. And the videotape sometimes is just,
Well, I've had that. Like I'm summarizing a deposition for the client, kind of trying to explain the way it went. They say, oh, well, let me see that. And I'll show it to them like, look, this guy's an asshole. I'm telling you, they're not going to like him. Right. Just and then they look at it like, well, that seems perfectly reasonable what that guy said. And it's like, well, I don't know. You'd have been there, I guess.
Yeah, no, you can't see the arrogance unless you're there watching the arrogance happen. And juries don't like stuff like that. I mean, juries especially don't like people that lie to them. If you can catch anybody in a lie on the opposite side of your case, you've gone a long way to winning your case.
Yeah, and it's one of the other reasons, I've had a goal, I guess, of I always want to be in one of these leaked deposition videos where there's, have you seen one of those? My favorite is the Texas deposition one. Have you ever watched that?
Yeah.
And I forgot the guy's name. It was Willie Nelson's old attorney.
Yeah, I can't remember either. But
I was thinking there was a potential for something like that happening. But I typically don't video. Maybe I should. I've seen some attorneys that come by and just set up their tripod and hit the record button. I think that Dan does that, doesn't he? Sometimes
he does, yeah.
And so, do you have to have a videographer to do your depositions, or can you?
Unless you can get the other side to consent, it's not going to be admissible in a courtroom.
Yeah.
So you got to get the other side to consent. So Dan usually gets them to consent and tells them, "I'll give you a copy of the video." But yeah, you got to get consent on that, unless you get a videographer.
Yeah. Well, I did not know that.
Yeah. Yeah, Dan does that a fair amount. I can think of a time, it was a long time ago when I was younger and feistier. But I had a lawyer ask me to step outside one time.
Really?
In the middle of a deposition, because he said something and then he objected to my question. I was like, "What's the basis of your objection?" And it was a BS basis. And then I said something else, and then he called me an asshole under his breath on the side, and I kind of went. And instead of letting it lie, I looked at the court reporter and I said, "Madam Court Reporter, did you note that plaintiff's counsel just referred to defense counsel as an asshole?" And he exploded. He flipped his books all over and asked me to step outside and fight me. And I was like,
if you'd have taken him up on it, do you think he was serious?
I don't know. I think he might have been. He's kind of a crazy guy. There was another lawyer in the room. And I remember looking at him and I go, did he just call me an asshole?
Yeah.
He goes, I don't know. I didn't hear anything. And then I said something on the record that, defense counsel believes plaintiff's counsel means to do him harm in the parking lot. And it was funny. And I was a young lawyer. And what was funny is at the end of that deposition, he took a break and left his client in the room. I talked to her for a minute. And then at the end of that deposition, he offered me a job.
Well, I guess he's impressed. What did his client? Did you get the sense that she was impressed with what he did, or that she was embarrassed?
She was embarrassed. She was almost going to cry, and she was just like, it's already intense. I was taking her deposition, so it's already intense for her. I mean, going through a deposition is no pleasure thing for anybody. So she was already kind of nervous, and then that happened, and she's like, "What in the world's going on?" She had little tears. It was terrible.
And it's interesting to see what people like. We were kind of talking about professionalism earlier, and I've known of attorneys that'll just blow you out on emails. Mm-hmm. I guess because the BCC button.
Yep.
And then just kind of, crazy emails that I've gotten from attorneys. Just. And then you see them in person, and they're the most pleasant people, and you get along with them fine. And I just presumed it's because the client's like, "Wow, my lawyer is really owning this guy." What's he going to do? And I guess you only see that one perspective, because if you're not, you're not going to reply all, you're not going to catch the response. So it's a way of kind of framing the issue, I guess, for your client. Although I would say in the long run, they'll find that that's not how it works in court or when things really matter.
Right. Yeah, that is not my style, the way of doing things. There are a lot of lawyers that is their style, and there are a lot of clients that's what they want. Some folks are just angry and upset, and a lot of times they're in the courtroom like for vengeance, and they want their lawyer to just be the wrath of God on everybody. That's not my style. That's not the way I'm ever going to be. I always feel like killing folks with kindness is the best way to draw information out of people. Yeah. But some folks, that's what they want, and I get it.
And that's interesting from as you primarily do defense work.
Yep.
I guess that's maybe more the stereotypes, is that the defense is kind of the bulldog or the go after them. But kind of in what I've seen is it's kind of the opposite. A lot of the defense attorneys I've worked with tend to have the kill them with kindness and you track more with honey type attitude. Sure. And it's the plaintiff's lawyers maybe that'll be the more aggressive sometimes.
Yeah, no, I think that's true. I'm lucky. I had good mentors coming up, which I think is probably the most important thing as a young lawyer that you can do, is just get lucky and be with the right people. I had John Drew Warlick up in Jacksonville, was my boss for 2 years, and just a gem of a guy, somebody I still talk to all the time. And then Don Ennis has been my partner for 25 years, and there's not a better gentleman lawyer in this entire county. Just a fantastic trial lawyer. He's like a big brother to me. I don't really do much of anything without talking to Don about it first.
Yeah.
But I've been lucky in that regard, and that's kind of their style. They're people you can, if they tell you something, you can believe it. They're not going to change unless, I mean, sometimes you have to change because your clients instructed you to do something differently. But men of their words, aggressive, are going to try to beat you to pieces. That's what the part I like about my job is it's like playing sports a little bit, doing the litigation. Yeah. It's me against somebody else. Somebody's going to win, somebody's going to lose. And that's kind of what drives me. I'm not like a distance runner. I'm not self-motivated a lot.
Yeah.
But if somebody else is trying to knock my block off, I'm going to go as hard as I can to knock their block off.
Well, and it's just the worst feeling. There's your fiduciary obligation, to your client, and then I've heard some lawyers have say that that's kind of like the 80% rule. Yep. Is that 80% of the cases are the same thing's gonna happen no matter who's the attorney. Right. And in 10%, somebody's gonna win because the attorney did a fantastic job, right. And the other 10%, somebody's gonna lose because the attorney just did a shitty job.
Right.
And so, you'd hate. I kind of agree with that. I mean, the percentages, who knows?
Right.
But you hate to be in that lower 10%, right. Where you're like, the only reason or the primary reason why this happened was because I didn't get it done.
Right.
And that certainly is a motivating factor.
And that's the nice part on the defense side of things. I get paid by the hour. So the more I work, the more I get paid. The more prepared I am, the more I get paid.
Yeah.
And sometimes on the other side, when you're getting paid like a percentage of the recovery, the more work you do, unless you bring something special to the table to add value to the case, actually like less you're making per hour. And I think that's always that's the difficulty on the plaintiff side of things, is trying to figure out how much is too much, and it makes it tough sometimes.
Yeah, I mean, especially, there's two components of it. If you spend all your time on a contingency case and there's really not that big of a recovery down the road,
right.
You're cheating yourself in that situation, or maybe not cheating yourself, but you're not going to make any money.
Right.
And the second thing is, if you're going around taking a bunch of depositions and hiring every expert, and the case isn't worth any money, then typically that's the costs are coming out of the client's
right.
pocket. And then you're going to have another conversation when all that's done.
Yeah. Again, you're a financial planner.
Yeah.
And hopefully you're having those conversations with your client on the front end,
yeah.
So you don't lose credibility on the back end, and they start thinking, well, you just don't want to try this case. You don't want to do any more work.
One of the things that's interesting in the kind of the plaintiffs community or representing plaintiffs is everybody's always got a cousin or a brother or a relative that had a similar situation and won $1 million,
right,
or something. And it's kind of like it's a straw man argument where
right.
It's like it probably never happened, but even if it did, it's probably apples and oranges.
Yeah.
But then you're always how much time do you want to spend, and you can get sideways with your client kind of getting into that.
Oh yeah, no, absolutely. That's kind of the nice. I've been doing this now 27 years. I've seen a lot of things and done a lot of things, and when I get those stories, I'll kind of laugh and go, well, I never heard of that before. Maybe you should go to that lawyer.
Yeah, that's kind of what I've told people right. Verbatim in the past. Well, and I know you were saying that you primarily practice in southeastern North Carolina. How would you compare kind of your typical jury pool in southeastern North Carolina versus what you've dealt with in other jurisdictions?
Yeah, southeastern North Carolina has just so dramatically changed over the last 25 years. My very first jury trial I ever tried in 1994 was down in Brunswick County, where Andy Anderson used to call me his pit lawyer because you literally tried the case. It was in a pit. I don't know if you ever saw that courthouse.
Was this Columbus County, you said?
Brunswick County.
Okay.
Before they built the new big courthouse, they used to have, you would walk down into this pit and you were your head was at the top of the jury box. Mm-hmm. And you were down low, and they're all sitting up there, and you used to sit right next to the plaintiff's lawyer. Your desk was curved around this circle around the pit. Mm-hmm. And he used to joke around, call me the pit lawyer all the time. But Brunswick County, you would usually have, a third generation yam farmer from Ash, North Carolina. And then you'd have some guy from Leland who might work in Wilmington, might have a shrimper from over in Calabash, and then you might have a guy from Bald Head Island on there, wearing a sweater vest or something, and you're trying to figure out how those guys are going to all agree on something, or ladies. I don't mean to make it all guys, but now Brunswick County, there's so many retirees that have moved into Brunswick County. You've got a lot of folks that are from New York, that are from Wisconsin, that are from Chicago, that are going to be on your jury pools, and that you've got to kind of keep apprised of all those kinds of things. And they're generally a little more conservative, I find, in Brunswick County. The older folks, retired folks, a lot of Fox News watching folks.
Well, and that's what I was going to ask: is if the retirees have brought their kind of the northern sensibilities with them as far as how they view things, or whether when they've reached the retirement stage of their life, they've become more conservative or kind of.
I think they become naturally more conservative. Those retirees do. The caveat that I would say is, where you had a shrimper, say, who might be making $22,000 a year shrimping, or 25 or something like that. Now you might have a guy who's a retiree with a couple $1 million sitting in his 401k, who might think in different numbers than, say, that guy down in Calabash did back in the day. So that'd be the one change, is the number part is a little bit different as to what their expectations are and what their thoughts are on numbers. Then you got Onslow County, which has got the military base, which is going to be relatively conservative as two. Duplin County has always traditionally been pretty conservative. New Hanover County is fairly conservative. You get out Columbus County, you start to get where Whiteville is, you start to get a little more, open, I guess. And then Robeson County is generally considered to be a larger damages county. They've had some unusual verdicts come out of that county.
So I wasn't there for the pit. They'd opened the new courthouse before I started going down to Brunswick County. Yep. But I do remember the first time I went to Columbus County, and this kind of I remember like a circular walkway like before the main courtroom, and
yep.
signs on the door, no smoking in the courtroom,
yep.
and kind of the nicotine stained wall, like the yellow ceilings everywhere in there. And I was like, well, this is interesting.
Oh yeah, absolutely. I mean, you'd go over there and the judges would be smoking all inside the judges' chambers, and there were ashtrays all over. Even, I mean, I bet you'd still find a couple ashtrays over there in Columbus County and Whiteville. But yeah, no, it was different times. And Columbus has seen a lot of change. I mean, with all the jobs moving to Mexico, all their textile mills closed. Those were all open when I first started practicing.
Columbus County at one point, wasn't it the haven for fire cases?
Yeah,
I think at one time I remember hearing a story where there was like a moratorium on fire policies in Columbus County
down by Tabor City. And matter of fact, my first day here in Wilmington, I went with one of my bosses to go look at a house that had burned down in Tabor City. And he walks me in and he says, "Did this house burn down naturally, or did somebody set it?" And I was like, "I don't know. I mean, I'm walking around. I've never even been in a house that's been burned down before." And when we start walking around, he goes, "Well, tell me if there's any clues." So we go. He takes me in the kitchen. He starts opening up the drawers in the kitchen, and there's no silverware in any of the drawers.
Yeah. Okay. Yeah.
And he goes, and I go, he goes, "Where did the silverware go?" And I go, "Oh, it must have burned up or whatever," because I'm just a knucklehead who doesn't think about the burning point of metal.
Yeah.
And then little things like, if there's a TV sitting there in their living room, there would be some wiring and a picture tube. The plastic might melt and burn out, but there would still be some evidence. So like TVs were missing, no couch springs, bed springs. And we end up figuring out that they had moved all their furniture out to a pack house on the back of the property.
A couple days before.
Yeah, and they lit the place on fire themselves. And that was a big problem back in Columbus County. It's not, I haven't seen any cases like that there in a really, really long time. But 25 years ago, that was something that happened a lot.
Yeah, those I think would be fun. I've had a couple fire origin cases where we're trying to figure out they were negligence cases. We're trying to figure out who to pin the blame against, but haven't done one of those first party fires where we're trying to figure out if it's an insurance fraud or if it's an accident. Yeah, no, I tried a fire cause and origin case up in Halifax County 22 years ago maybe, and we tried it for 2 weeks, and it was all it's almost kind of like, it's pretty sophisticated science, but they look for the burn patterns, they look for where the most intensity of the fire is, and then they kind of backtrack. And it's easy to find people that'll disagree, but I ended up hiring a metallurgist in that case, and we were able to find out that it was a electrical duplex outlet that caused the fire.
because of a blob of copper at the end of a wire. So they're fun cases. And it's a lot different than anything else you'll try.
What would you say is the most common, like the mean of the cases you do? What's kind of your average run of the mill?
Probably it's still car stuff. Car wreck stuff is probably the most common stuff, and then after that, I got a lot of animal cases with dogs. I got a monkey case.
A monkey case.
I had a monkey that attacked a lady that a guy owned down in Brunswick County, and I just got that resolved last year. It was a Japanese snow macaque that got out of its cage.
I feel like I could deal with a dog. I mean, I guess some dogs are more dangerous than others, but that would freak me out if a monkey came after me.
No, it's something with hands and it's on top of you, man.
A worthy opponent.
Yeah.
Probably very fast.
Yeah, it was a 50-pound Japanese snow macaque, and I don't mean to laugh at it was very traumatic what happened to this woman. But he had escaped his confines, and the thing I learned that was amazing to me is it's not illegal to own one.
Yeah.
And there's almost very little law unless your local county or your local town has law on it. There's no law. You could have a lion if you want to.
I wouldn't wish that on my worst enemy. At least the monkey attack. But I did watch the Tiger King.
Yeah.
And so once I realized you get a tiger for $2 or $3 grand, I was kind of thinking, well, this might be a good idea.
Yeah.
But
it's not.
No. Well, I'd take my chances against the monkey over a tiger for sure.
I think so. Although, man, monkeys, oof, it was scary. But yeah, so I some of that kind of stuff, a fair amount of construction, litigation, real estate stuff where folks are arguing about, usually it's in purchase of homes. Cow cases, cows up in Duplin County, cows get out of their confines all the time and get hit, and there's all sorts of lawsuits over that. And
my cousin forgot to close the gate at my grandparents' farm one time.
Yeah,
I've certainly seen that.
Yeah.
Saw the cows along the highway on the way home.
Yep, I just got retained in the. There was a Legionnaires outbreak out in Henderson County, where 140 people were exposed roughly to Legionnaires, and I've gotten brought in as counsel out there to represent a hot tub company that was, I guess, using their hot tubs at the time, and that's allegedly how the folks were exposed. 4 or 5 people died. Right now, I think there's 40 lawsuits filed out that way right now. But I don't get out. Usually my little corner is southeastern North Carolina. I don't get out across the state a whole lot.
Have you seen a decrease in the volume of kind of your standard car wrecks since the tort reform?
I have not. Nope. Just as many. I think there's just as many. And really, it's like we've taken a time warp back to like 1993. Because when I started practicing, you would go try one of those cases, and you would have about what the bills were actually what they said the bills were. Mm-hmm. I mean, and then as insurance started having their problems, and they started billing like 3 times what they had been billing before for a procedure, because they're only getting paid 50%.
Yeah.
Then things kind of got out of hand. So a lot of cases that would settle back in the day, because maybe there's $100,000 in medical bills. Now maybe if it's Medicare, there could be $15,000 in medical bills, and that's what's going in to evidence. So that's a case that would not have even saw the light of a courtroom before. So I don't see the downturn. I know some of the guys that were really heavy into that were making just phenomenal livings off of that, have been upset about it because they can't quite get to that same level they were before. But there's a lot of young guys that would love those cases that are all coming through.
So I think that's interesting as far as the evaluation of like what you're going to offer to settle a case, or what you're going to ask for if you're the plaintiff, because it seems like for as long as I've been doing this, it seems like the main driver of what's a case worth is the medical bills.
Right.
But I think in this kind of environment, what you see is 90% of the time, whoever was injured most likely had insurance, health insurance to pay the bills, or if they're broke, it was most likely Medicaid.
Right.
So and I would presume that most people are aware of that. I've had a couple of those trials where, the jurors can ask questions. They'll send a note back to the judge and say, "Hey, I just wanted to let you know." They wanted to know if the defendant or if the plaintiff had health insurance and stuff like that. So I guess there are situations where that is kind of where they don't know, but I think they make assumptions based on those sort of things, because it's just kind of your average person in the community, I would assume, knows how that dynamic works.
Well, typically you got 12 strangers sitting in a jury room, and you're going to blackboard your numbers, right? So if you're the plaintiff's attorney, you're going to blackboard your numbers. Medical bills is easy. If I'm found at fault and you're not contributory negligent, you get your medical bills. The law is very clear. Assuming they're all approximately caused by the accident. Now, if I can go through and say, hey, that back surgery you had actually is because you hurt your back the year before, not because of this 5-mile-an-hour accident that happened out on the highway. But you're going to get your medical bills. Then they're going to put their lost wages in. Then they're going to factor in future lost wages or future medical bills if there is such a thing like that. Then you're going to get permanent injury, scarring, disfigurement, all that kind of stuff that they'll try to blackboard. And then you got pain and suffering, which is, how do you, how does that get figured out?
How do you deal with that as a defense attorney? Do you concede that pain and suffering is something they're owed if they experienced, or do you even tackle that issue?
Yeah, I tackle that issue. We all, we've got 5 lawyers in our firm who've been trying defense cases for, Baynard and Don and Dan have been doing it 35 years each. So yeah, we attack. I know there's a lot of people that feel like if you've got a liability defense, you don't talk about damages. I almost always talk about damages. I think you go ahead and buttress your liability arguments with the damages arguments and don't give up that ground. So, you go through a reasonableness type thing. You go through, look, it's easy to feel sympathy for somebody, but you're not allowed to consider that. And that's what you agreed to when we picked you as a juror, that you weren't going to get caught up in the sympathy part of this thing. You got to look at the hard facts and how much is that person's pain and suffering work. And, sometimes they'll make a per diem argument or a that's worth this much per year and all that kind of stuff. I find those arguments a little disingenuous, but I understand why you make them. The plaintiffs, just like the defense attorney's job is to try to keep the judgment as low as possible, the plaintiffs is to keep it as big as possible. And they want to inflame and get the jury upset, and I'm always trying to gear it back the other way and keep them calm and say, hey, look, let's really look at what this is.
Well, to me, it always brings back to the golden rule argument. And it's like, because I think probably the most fair thing or the way that kind of I would approach it if I was writing the laws would be maybe, well, what would, from pain and suffering standpoint, what would somebody have to pay me to go through that?
Yeah.
Is kind of what I think of.
Yep.
But I guess that's your classic golden rule. That's not that's impermissible. You can't make that argument.
Right. You can't make that argument, but they're all doing that back in the jury room, I think.
Yeah.
There's always kind of a little bit of a joke, like how much would I have to pay you to crack a 2x4 over your back?
Yeah.
Like, I don't know, you give me $4,000, I might let you crack a 2x4 over my back. I don't know.
But I think what you said made a lot of sense about attacking it from a liability or a damages perspective, or maybe not attacking, but just getting into the damages if it's a liability case.
Right.
Because of what you said earlier with juries don't like liars. So
right.
if you can catch somebody embellishing just maybe a component of their damages that doesn't even matter.
Yeah.
A lot of times like lost wages or trying to throw in an insignificant medical bill that doesn't really matter in the long, but if you can catch somebody doing something like that.
Yeah, or somebody, like somebody says, no, I never had any back pain before this accident. And now I go get your prior medical history, because in order for me to try to even evaluate your case, I got to know where you were medically before you ever got in this accident. So, you sit there and you get their prior medical history. They all say, no, I've never, not they all, but oftentimes, my back done hurt. I never had any problems with my back. And here I find oxycodone prescriptions that you've been taking for the last 5 years, and you went to chiropractor last year, 100, and you've been in 8 car accidents. You can tell me about any of that. You can get all that kind of stuff in front of a jury. They're already looking at the plaintiff a little bit skeptically because they're there asking for money. Mm-hmm. Right? So then if you can put that together and now show and really establish that person is being greedy or trying to game the system or is puffing their numbers, juries typically don't like that.
So in my experience, I agree with what you said, that the common juror you come across in this area views a plaintiff skeptically when they're making a personal injury claim for damages. But the flip side of that, when I've represented real estate investors or businesses in a business dispute,
right,
a lot of times those claims are way more speculative than the guy that got T-boned.
Right.
And they're looking at that guy like, everybody's back hurt, so what?
Right.
But then my guy's saying, well, if not for this condemnation or not for this the actions of this real estate broker or whatever it may be, I would have really shot the moon, or I would have made all this money and everything would have gone perfect, and,
right,
and everything, things that it never works out like that. And people are, oh yeah, that makes sense.
Yep.
People seem to feel more sympathy for
Right.
the businessman that missed out on the multi-million-dollar opportunity where everything was going to go to plan than the guy that got in a car wreck that wants.
I think there's a real perception out there that people are gaming the system, lawyers included.
Yeah.
And heck, I live on that parasite too, so I'm not trying to say I'm some better, but you get in a car accident today, you're going to get 5 videotapes and 8 letters from various lawyers from all over, whether you were, injured or not injured or whatever. And folks kind of all know that, and they see the advertising on TV, and they see all those sorts of things. And here is much more tasteful than where you go to a lot. You go to some of the bigger cities, and there's some pretty egregious video commercials that I see up there that are almost kind of funny, but they're not. And I think that's where that difference is. I think folks are looking skeptically because they're already, the whole ambulance chaser metaphor and all that kind of stuff that's out there. I think folks understand what happens.
I think that there's not enough money in personal injury practice, like mass personal injury practice, to do that anymore. Because I go down. My dad lives in southeastern South Carolina, and so it's on the border with Georgia, and so we get the Georgia television ads and the Charleston ads, and you see all that stuff in Savannah and Charleston, which are probably bigger than Wilmington, but comparable, comparably sized cities, and you see all that stuff. The themed, like the Hawk and the and the ambulance chasers, and like I've talked about it before, but my favorite ad was a guy like running like the firm, and he's just like running, and at the end he reaches the ambulance, and that was one of them from Savannah, and they're just upfront about it. There's rapping lawyers in Savannah. I mean, they're really funny, but it's like, who's got time to put that together in North Carolina with kind of the way our laws are structured.
Yeah, no, the 414 issues really had an effect on the bottom line as to what you can do, and I think they're probably. I still think, I know I get yelled at, but that's about the fairest law. Like, your bill is what somebody's willing to pay for your bill. I mean, your bill isn't what somebody writes down on a piece of paper. Like if you had a car and, you try to say, well, the sticker price on this car was $80,000 and we've got a dispute over it, but I know you paid $70,000 for that car. You don't get to put the $80,000 that somebody wrote down on a piece of paper in there. I mean, and it's this, and health insurance has gotten to that point where they've bump those bills up so high, but they're willing to take 30 cents on the dollar, 40 cents on the dollar. It just but I understand the counter argument.
Yeah, it's just kind of it's difficult really to determine what's real and what's not with the bills, because you got a whole different depending on your lot. You got the same procedure could cost 10 different things. And it's usually a pretty wide range too. Well,
and the flip side is, the chiropractor cases might be worth more now because health insurance never pays chiropractor bills. So those bills are always what they are. And then you've got all the games where some of the doctors and some of the hospitals aren't submitting their bills, and then some are selling them to lien companies like Key Health, and then that's a whole disaster mess road to go down to try to ferret out all that too. So
I had early on when the tort reform laws were new and kind of everybody's trying to figure out what's going on, I would have situations where some of my clients, the medical providers would take the position that they're not going to accept insurance, if it's a third party liability case, but they're contractually obligated with the person's health insurance company to take it, and and it's one thing if it's a clear cut automobile accident where there's going to be a payment versus you're in a slip and fall, or you don't know if the third party's got insurance, or there's a lot of things that can happen, and I found it kind of offensive that they were doing that, but it's one of those things where going back to what you learned for in law school, it's like when I was in law school I was probably thinking, oh, that'd be great, I'm gonna take down the insurance, I'm gonna take down the hospital and sue them for breaching their contract, and then now you're looking at like, I don't have time for that, and that's fighting City Hall, and it's up, they don't do that anymore, but it certainly was a problem, and you'd kind of get it on both ends from the plaintiff side, because you're getting it from the hospital who's after your client to pay their bills, and they want full freight, or they want you to sign an assignment of benefits and all that, and then you're getting it from the defense, which is saying you didn't mitigate your damages because you didn't submit your insurance claim, or because you didn't take advantage of your insurance benefits.
We had a trial over at our office that Ron Medlin was trying, and the hospital wouldn't submit the bills, and it was like a $5,000 bill, I want to say, and they were pretty close together. Like the settlement number wasn't too bad, but they're Monday morning sitting there getting ready to try a jury trial. The judge gets up on the bench and they have this motion in limine about whether that bill should be submitted or not because it hasn't been, tendered for any kind of coverage and can't meet the 414 standard. And the judge put out a bench warrant for the billing clerk at New Hanover and said, "You need to come down here and explain to me why this hasn't been done." And they zeroed the bill out immediately.
Wow.
And the case ended up getting worked out. But
good for the judge.
Yeah, but that goes to your point. It makes it difficult for the plaintiff to try to even resolve the case because they can't figure out who they're supposed to pay and how much they have to pay. And I mean, it almost forces you all into court in some situations. So it's tough.
Yeah, it certainly makes it difficult. Well, Steve, I appreciate your time and I appreciate you coming on. I'm getting ready to enjoy my professionalism, secure leave in a little bit. So it was good talking to you as always. And then thanks a lot for coming on.
You too, Justin. I appreciate it, man. Stay COVID free, y'all.
Yeah, I'm going to try.
All right.